Welcome to the deep dive. Today, we're digging into something that feels pretty routine for lots of business owners, but it actually carries, well, a surprising amount of personal risk if things go sideways. We're talking about directors' loan accounts.
Yeah, it's fascinating, isn't it, how this really common thing, just taking money from your own company, can flip into a major personal liability.
Yeah.
What often happens, I think, is directors sort of see the company funds as, an extension of their own bank account. They forget that crucial legal separation.
Right. The company as its own entity.
Exactly. And that distinction, it seems small maybe, but it becomes hugely important if the business faces insolvency.
So our mission for this deep dive is simple. Get you up to speed fast on this quite nuanced area, and critically what you can actually do to protect yourself. Okay, let's unpack it then. Lots of company directors, maybe even you listening, have probably dipped into the business cash using a director's loan account. Feels natural, right? Your company feels like your money. But the key point, and where it can get, well, messy, is what happens if that account goes overdrawn.
Exactly right. So a director's loan account, it's basically just a formal record. It keeps track of the money you've pulled out versus what you've put back in or been credited. Now, if you've taken out more than you've repaid or been formally allocated, like through salary or dividends, then boom, it's overdrawn. You personally owe the company money.
Okay, that makes sense. And fine when the business is doing well.
Precisely. But the whole picture changes dramatically if the company hits financial trouble, becomes insolvent, or, worst case, enters liquidation. That debt you owe, it doesn't just vanish. It becomes a very real personal responsibility for you to pay back. I've seen it happen. A director borrows for, say, a personal emergency, fully intends to pay it back fast.
Sure, life happens.
Exactly. Then the business hits a slump, and suddenly that quick loan turns into a serious legal problem.
That really brings it home. So let's talk about the seriousness here. When a company goes into liquidation, an insolvency practitioner gets appointed.
The liquidator.
And their main job, their legal duty, is clawing back money for the company's creditors.
Yep.
And guess what's usually high on their list to collect?
Any debts owed to the company. And that includes your overdrawn director's loan. It's not just about getting the money back. It's about being fair to everyone the company owes money to.
So this is critical because that liquidator can then come after you personally for that money.
Directly, yes. And this isn't just a polite request. It can escalate quickly formal demands, potentially court action.
Leading to...
In serious cases, it could even push someone into personal bankruptcy. It's often a massive shock, particularly if the money was taken out informally, maybe without great records.
Which probably happens quite a bit.
More often than you'd think, sadly. Many directors just don't fully grasp that the company's bank balance isn't their personal piggy bank.
Okay, so it sounds like taking action early is absolutely vital. But, if a director's business is already struggling, finding cash to settle that debt might feel impossible. What can you actually do before it gets to the formal liquidation stage? Is that really the best approach?
Oh, absolutely. It's by far the best path. The good news is, if your company is still trading, even if it's technically insolvent, struggling going, you have a window, a chance to act. You don't need to wait for that official liquidator to be appointed to start sorting out an overdrawn loan.
And why is acting early so much better?
Because once that liquidator is in place, their hands are tied to some extent. Their legal duty is clear. Recover as much as possible for creditors.
All right.
That often means pursuing you for the full amount owed with very little wiggle room.
Right. Less flexibility.
Much less. But if you tackle it before formal liquidation kicks off, there's significantly more scope for negotiation. Specialists can often help you reach a settlement on that debt before the liquidation process even begins, and potentially settle it for less, sometimes much less, than a liquidator would be forced to chase you for later.
Ah, okay. That makes a huge difference.
It really does. It puts you back in control, lets you manage the situation, maybe proceed with a voluntary liquidation on better terms, and with far less personal financial risk hanging over you. It's like finding your own way out of the woods instead of being dragged through them.
That's a really powerful way to put it. So the key takeaway from our deep dive today seems crystal clear. Proactive, early action is everything. It really is about grabbing control of the situation before it totally controls you, turning a potential crisis into something, well, manageable.
Exactly. And that brings us to a final thought, something for you to maybe reflect on. What really stands out to you about these sort of hidden financial links between how healthy your business is and your own personal financial well-being? It's quite a stark reminder, isn't it? How seemingly small, maybe informal money decisions within the business can echo and have pretty significant personal consequences down the line.